Welcome to the Ohio State Legal Services Association's Family Law Video Project. This video was made possible through the generous support of the Ohio Legal Assistance Foundation, and the content was created by Southeastern Ohio Legal Services and the Legal Aid Society of Columbus. The video you are about to watch will guide you through some of the forms that you will need to file in Ohio courts when you want a divorce, or you need to respond to a divorce your husband or wife filed. The information we provide is not legal advice and does not create a lawyer-client relationship with you. We cannot guarantee any specific outcome in your case, and we are not responsible for any errors on your form. You should hire a lawyer if you can afford one, especially if your divorce case is complicated. This may mean that you and your spouse do not agree on custody of your children, you own real estate, you have a lot of property to divide, you or your spouse have retirement accounts, your spouse hired a lawyer, or if one spouse has a much higher income than the other spouse. If you need a lawyer or specific advice about your case, you have several options. If you are low income, you can contact your local legal aid program. If you need information about which legal aid covers your community, call the following number. Many communities also have pro bono clinics where low-income people can talk to a volunteer lawyer. Your local legal aid program will have a list of clinics near you. Finally, if you can afford a lawyer, you should reach out to your local bar association for a lawyer referral. The forms you will be completing can all be found online on the Ohio Supreme Court website here. The forms available online may be completed in Microsoft Word or PDF form on a computer. If you are not able to complete them on a computer, you can handwrite the forms. Be sure to print as clearly as possible and always use a pen. Some courts require you to use a pen with blue ink or black ink, so you may want to check with your local clerk of courts on ink requirements before you fill out the forms. Note that just because the Supreme Court is providing these forms, you will be filing them in your local courts, not the Supreme Court. This is not the only form you will need to complete. At the end of this video, you will see a list of forms that you will need to fill out if you are filing a divorce or if you are responding to a divorce complaint. If you complete and file the Supreme Court forms listed, that should be enough to get your divorce case started or respond to a divorce complaint. However, your local court may require you to also complete additional forms. Keep in mind that you might be watching each video more than once, as sometimes you will need to gather additional information that you don't have on hand during the first attempt.
This video will cover how to complete a motion and affidavit for temporary orders. This is an optional form in a divorce case, but if you want the court to make decisions about issues like custody on a temporary basis before the final divorce hearing, you should complete this form. At the top of the first page, you should see the phrase, "In the Court of Common Pleas." On the next line, write in the name of the county where your divorce complaint is being filed. Next, you should fill in the names of the plaintiff and the defendant. Directly below the court name and county, and to the right, write the case number on the line that starts case number. Use the case number on the complaint. If there is a judge's name or a magistrate's name listed on the complaint, write those names on the lines under the case number. If the judge and magistrate's names are not listed on the complaint, it is okay to leave these lines blank. Check the box to indicate if this is a motion and affidavit for temporary orders or a counter affidavit. A counter affidavit is filed to respond to a motion for temporary orders that your spouse has already filed. Next, you will need to again indicate if you are filing a motion and affidavit for temporary orders or a counter affidavit. If you are filing a motion and affidavit, you need to check the lines for what types of temporary orders you are asking the court to make. At the top of page 2 in section 1, fill in information about your current family living situation and where the minor children from your marriage are living. In section 2, if you have school-age children from the marriage, complete the information about where they are currently enrolled for school. In section 3, tell the court what temporary custodial orders you want the court to make. Note that these forms use the term parenting time, which is time that the non-custodial parent may spend with the children. This has traditionally been called visitation time. At the top of the third page, if you and your spouse have agreed to a temporary plan for parenting time, you can write what the agreement is on the lines provided. If you have not come to an agreement, you can leave this section blank. If you request supervised parenting time when your children are visiting with your spouse, you will need to have very specific reasons for this request. It is best to talk to an attorney about supervised parenting time. In Section 4, if a court has already made a child support order, list the information about the order in this section. In Section 5, if you are asking the court for a temporary order that your spouse makes certain payments, you need to list the amounts you are requesting in this section. Be specific in the debts and/or expenses section about what you want your spouse to be ordered to pay. In Section 6, indicate whether or not you would agree to attend mediation. If there is a history of domestic violence between you and your spouse, you should talk to an attorney about mediation before you agree to attend. At the end of the form, there is a section with the title Oath. You must sign this document in front of a notary. Print your name on the first line. While a notary is watching you sign the line above your signature. The lines in this section beginning with sworn before are for the notary to complete. You can find a notary at most banks. If it's your bank, they will usually notarize documents for free. The clerk of courts will not notarize your documents for you. In the notice of hearing, you should talk to the clerk of court about how to fill out this section. On the last page, you will need to complete the certificate of service. You not only need to file this document with the clerk of court, but you also must serve your spouse with a copy, which means you need to send a copy to your spouse's attorney or your spouse directly if he or she does not have an attorney. Talk to a lawyer about deadlines for filing and service. Follow the instructions to complete the information about the date you are sending the document, the name of your spouse's attorney and the attorney's address, or your spouse's name and address if he or she doesn't have an attorney. Check one of the boxes for how the document is being delivered. Sending it by U.S. mail is usually the best. Sign your name at the end of the certificate of service section.
You have reached the end of this video. Remember that if you still have questions about how to fill out the forms for your specific situation, you should talk to a lawyer. If you need a lawyer or specific advice about your case, you have several options. If you are low income, you can contact your local legal aid program. If you need information about which legal aid covers your community, call the following number. Many communities also have pro bono clinics where low-income people can talk to a volunteer lawyer. Your local legal aid program will have a list of clinics near you. Finally, if you can afford a lawyer, you should reach out to your local bar association for a lawyer referral. Remember that this is not the only form you will need. Here is a list of the forms you will need if you are filing a divorce or if you are defending or responding to a divorce. If you complete your forms and wait a period of time before you file the forms, it is your responsibility to check the Supreme Court website to make sure that there were no changes to the forms since you first completed them.